Hey everyone, welcome back to the Irretrievable Breakdown podcast where we discuss all things divorce. I'm Matt Dolan with Dolan Divorce Lawyers in Connecticut, and as usual, I'm joined by my co-host and the managing partner of our firm, Nicole Bikakis. And today we are going to discuss custody relocation, so what the courts consider when determining whether or not to allow a parent to relocate to another place with their child or children. But before we get into that, Nicole, how's your week going? Have you been watching any of the World Cup? What do you make of this red card being overturned? By the time this comes out, the game will have already happened. But what do you make of this turn of events and the red card? What's the guy's name who got the red card?
I don't even remember his name, but I know the scandal surrounding it. And it's that it shouldn't have been a red card. I think everyone agrees that it shouldn't have been a red card. It only was called as a red card after they did the now playback, what do they call it? The VAR.
VAR, yeah.
And I don't know, all the commentary I saw was basically there was no intent or malice, and that it otherwise would have never been a red card. So
although when I was watching, and they were doing the review, the announcers didn't seem shocked that it was a red card. Like before it was converted to a red card, they said yeah, it seems like a borderline situation. So it didn't seem like that egregious of a red card call. I mean, I don't know anything. I watched the World Cup and that's about the extent of my soccer knowledge. So I was just basing it off of the announcers who I assume know what they're talking about.
I mean, I do think all the commentators afterwards, though, everyone was sort of like, this is why VAR is ruining the game.
Yeah. But all right, so that aside, what do you make of the red card suspension being lifted?
Yeah, that makes no sense. I mean, I think you either retract the red card or you hold up the suspension.
Well, I don't think that's a thing. I don't think they can retract the red card.
I don't know. I am disclosure, I'm not an expert on soccer or the rules, but commentators that I've been just following and seeing clips of their commentary have said you can sort of retroactively invalidate it or something.
Yeah. I don't know. I just think it shows that FIFA is the most corrupt organization.
We're gonna go there on this podcast. Okay. Yeah.
I think that's sort of a universally understood thing, right?
Yeah. I mean, so. It should be.
I don't know a ton, but the whole thing's just very bizarre, and I don't know. It makes it a little harder for me to root for the U.S. to be honest. When I feel like this guy probably shouldn't be playing in this game.
In the last game, though, after he got that red card, and we're down a player at the 62nd minute or whatever, and we still are able to score and win the game. Yeah. I mean, I thought it was really impressive. They played well. So, this just kind of undermines that.
Yeah. It's why can't it just be a normal circumstance where there's not this weird thing going on? But all right.
We're excited to find out what happens tonight.
Yes. And this will probably be old news by the time people are actually watching this. So that's all right. So custody relocation. So there's sort of different scenarios of custody relocation. There's post-judgment. So after there are already orders in place and there's a set parenting plan and one parent wanting to relocate. And then there is pre-judgment. So, a parent trying to relocate when there are no existing parenting plan in place already. And they follow two different standards. I think the more common relocation scenario is when there is already a parenting plan in place. So we're going to start with that. And the rule is dictated by Connecticut General Statute Section 46B-56D. And it first lays out what a relocation is. So relocation is when a parent's move would have a significant impact on an existing parenting plan. So that is not any set number of miles or anything like that. It really just depends on the scenario, but it could be, a move across the state could be considered a significant impact on a parenting plan, whereas a move to another state maybe doesn't. So if two parents live in Hartford and one person wants to relocate to Stanford, that would probably have a significant impact on the parenting plan. Whereas if two parties lived in Stanford and one person wanted to move across the border to New York, that probably wouldn't. So it's not necessarily a state line situation. It is just what change to the location of the parents would have an impact on the parenting plan. So when a parent does want to relocate post-judgment and take the children with them to wherever they are going to relocate, they have to prove by preponderance of the evidence. So that means they have to prove to the court that it is more likely than not that the following is true. And there are a number of factors they look at. So first, the court has to find that it is more likely than not that the relocation is for a legitimate purpose. Second, they have to find that it is more likely than not that the proposed relocation is reasonable in light of that, purpose. And third, the court has to find that the relocation is in the best interest of the child. So let's start with the first prong that has to be fulfilled if a parent wants to relocate post-judgment, and that is the relocation is for a legitimate purpose. So Nicole, what would be examples? What's the court looking at when they're determining whether or not the relocation is for a legitimate purpose?
Well, what they're looking at is making sure that a parent is not moving solely to basically alienate the child from the other parent, or to kind of, to execute like a custody grab, right? Like taking the child further away so that the other parent doesn't get to spend the time that they have been spending with the child. That would, of course, be like an illegitimate purpose. But, common legitimate purposes that we see a lot are, for a job opportunity, increased income, or better career opportunities elsewhere. The existence of extended family support. So someone who needs more support, whether that's because of the type of job they have, but the presence of extended family that can really help improve sort of the support and care the child gets. That would be a legitimate purpose. We've also seen, where parents following a divorce then kind of go on, they remake their lives, and they meet and they new people, and they have a new partner, and like sometimes that partner has like a new job opportunity in a different location, and so this is sort of like a new family unit, and that family unit wants to relocate again. Typically it's a career opportunity or job opportunity. Those are common scenarios where you will see a relocation request submitted.
Right. I think another one is maybe if somebody's kind of struggling financially and they're a different location has lower cost of living,
Yeah.
for example, that could be another legitimate purpose.
Or even where a family member is ill, and they need to go and support and be there for their family. You really have to look at it from a lens of, why are they moving? Are they moving for a legitimate reason? Are they moving because it's some kind of family obligation that they have? Is it an economic decision, or is there, like you said, are they struggling here? And there's a better both emotional, economical, educational opportunities for the child elsewhere.
What if it's just like, I want to move to Florida. It's warm there. Looks pretty nice. I want to go there.
That's definitely not a legitimate reason to move. Again, unless the other parent agrees, like we didn't really talk about this yet, but if you need to move for whatever reason, and the intent is that you want the child to move with you, if you have a good relationship with a co-parent and you can work it out together, that's great. That's the most sure way that you're going to actually get to move. But if where the other parent does not agree, and now you have to go through the process of filing the motion with the court and proving to the court the bases that we're kind of going through right now, that it's for a legitimate purpose, that it's reasonable in light of that purpose, and it's in the best interest of the child, um, then, the other parent objects, and obviously you have to go through this process, and it's very tricky. It is an uphill battle
Right.
to win on a relocation motion.
Right. All right. So that's the first prong. The relocation is for a legitimate purpose. The second is that the proposed relocation is reasonable in light of such purpose. So what does that mean? How is that different from the first prong?
Well, so I guess, like, for example, if let's say it's you're moving for a better job opportunity. Well, it's like, does that job opportunity exist where you are, or maybe somewhere closer to where you live now, where there would be a relocation would entail a less far away move. What they're really looking at is, how are they going to, if they allow a parent to move, how is that child going to maintain its relationship with the other parent, right? So to the extent that there's a more reasonable location you could move to, or if the reason why you're moving, you could just, if that reason, if that, there could be a solution where you currently live to avoid the move, the court will say, well, this isn't reasonable because you can just accomplish that here without moving and without having to upend the parenting
Right.
plan.
So it could be like, I want to move to California because there's better job opportunities. Hey, I have this job in California and it's making 25 cents an hour more than my current job. Well, the purpose of wanting to have a better opportunity, that is legit. But if the reason is that you're moving to California and it's only 25 cents an hour more, that's not legitimate. That's not that second prong would not be fulfilled.
Because again, even if you're moving for economical reasons, say you have found a job that is going to pay more, like making more does not equal like better for your child automatically. There are a lot
Well,
of
that
other
gets to the
factors.
third prong. So the third prong is that the relocation is in the best interest of the child. So you could have a completely legitimate reason for moving to a different place. Moving to that place is the only way that you can fulfill that, that legitimate purpose. But you also have to show the court that the move is in the best interest of the child. So we've done a separate video that talks about what the court considers when determining whether or not something is in the best interest of the child. But the court's really going to be looking at like, all right, this is going to likely create a situation where the child is no longer close to both parents and is going to have very limited access to the parent who is no longer living close by to the child. So, you're fighting an uphill battle in getting a court to find that living in this other place is in the best interest of the child, that not seeing both parents on a frequent basis is in the best interest of the child. That's a very difficult thing to accomplish.
Or even just generally uprooting a child from their home, right? From what is familiar to them, from their current school environment and friend environment, and that other parent and that parent's extended family, and sort of what they're comfortable with, what they know. So moving is sort of an emotionally taxing thing for a kid to go through, starting at a new school and like a new town where they have no friends. That's not something you don't pursue that unless there's a really legitimate reason for kind of uprooting them from the environment that they're comfortable in. Again, assuming that the environment they've been living in has been working well for them, right? That they seem to be happy, well-adjusted children, and the parenting plan seems to be working. Because the court will go into an analysis also of each parent's relationship with the child.
But let me also just highlight the fact that just because you're relocating to another location, which could be far away, that also does not necessarily mean that it will have a significant impact on the parenting plan. If your current parenting orders are that you have sole legal custody and the other parent has no visitation or parenting time with the child, you can sort of move wherever you want, because you moving from Connecticut to Pennsylvania, it's like, there's no parenting time in the order. So you moving to another location doesn't change the fact that there's no parenting time. Or if you live in Connecticut and your spouse lives in another state that is far away and they already have pretty limited access to the child, maybe every, alternating school breaks or, X amount of weeks during the summer, if they're already far away and have limited access, you moving to another state does not really change the parenting plan. They would still have that limited access. If you moving does not impact the parenting plan in a significant way, you can just move and you're not restricted. Now, with that said, before you move, if you have any doubts, check with a lawyer to just double check to make sure that your move is legitimate, because you don't want to be in a situation where you move and then the other side files a motion for contempt and you're potentially violating a court order and you didn't follow the rules of the statute, etc.
Well, because and if you have a parenting plan where the other, like, let's say you do have primary physical custody, even if you have sole legal custody, but as part of the parenting plan, the other parent gets to see the child weekly or even bi-weekly, that is going to get impacted if you're moving far away. So there's no way around that. For that, in that scenario, you need to seek the court's permission to relocate unless the other parent agrees, and you can come to an agreement. And then also, we covered this in our last episode, parenting plans do have relocation provisions often included as part of the parenting plan. So look at that relocation provision and make sure that you're also following your agreement.
Right. Okay, so those are the three prongs. And then when determining whether or not to approve a post-judgment relocation, the court is required to consider a number of things. So first, it must consider each parent's reasons for seeking or opposing the relocation. Second, the quality of the relationship between the child and each parent. So they're going to look at, all right, does this child have like a really bad relationship with the parent who is not trying to relocate and, hardly ever sees them? That's probably going to make the relocation a lot easier for the parent who is seeking the relocation. Whereas if they have a very strong, close bond with the parent who is not trying to relocate, it's much less likely that the relocation is going to be granted. They are also required to consider the impact of the relocation on the quantity and quality of the child's future contact with the non-relocating parent. So that's sort of similar to what I just talked about. They're going to be assessing, how they can maintain the strong bond with the non-relocating parent if the relocation were to be granted. The court's required to consider the degree to which the relocating parents and the child's life may be enhanced economically, emotionally, and educationally by the relocation. And finally, the feasibility of preserving the relationship between the non-relocating parent and the child through suitable visitation agreements. So there's a lot of overlap between those factors, but the court is going to be assessing all of that when deciding whether or not it's in the best interest of the child to grant the relocation.
Almost always when a parent is bringing a motion for relocation post-judgment to the court, you are also getting either a guardian ad litem involved, or the family relations office in the court is going to be conducting a relocation evaluation. So they're going to be looking at specifically for evidence of all these factors, in addition to assessing, okay, the parent who's looking to move, where is this proposed relocation to? What is the plan once you're there? What are the opportunities? Where are you proposing to move with the child, and what type of housing is going to be available? What type of schooling is going to be available? They're going to look at all of that in assessing whether they recommend a relocation or not.
Right. All right. So those are post-judgment relocations and how it is dealt with in the court. Now let's back up and talk about one parent seeking to relocate to another place when there are no existing custody orders that have already been entered. So let me first start by saying, if the divorce has already started or the custody matter has already started, but there are no orders in place yet, let's say somebody filed a week or two ago, you can't just up and leave the state of Connecticut with the child. There are automatic orders that go into effect when a divorce or custody action are started, and those say that neither parent shall permanently remove the child or children from the state of Connecticut. So don't try the move of saying, all right, I'm just going to move quickly. I want to move to Florida. I've always wanted to move to Florida. I'm just going to pick up and leave because there's no court orders that say I can't do that. They are called the automatic orders. So if you do that, it's just starting your case off on the wrong foot. A judge is not going to be happy with you, and you are almost certainly going to be required to move back to Connecticut. But let's assume, you don't just pick up and move and your custody or divorce case is ongoing and you're trying to work out a parenting plan and you're trying to reach an agreement on whether or not you can relocate with the child or children away from where you have historically lived. Now, if there are no existing orders in place, you do not have the burden of proving those three prongs that we talked about. The court does not have to go through the specific analysis of evaluating certain things. It's just the pure analysis is that the court is determining whether or not you living in this other location with the child or children is in the best interest of the child or children. Again, we've already done a separate video on what factors the court usually considers when determining what is in the best interest of the child. So you're just going to want to look at those and go through each factor to try to analyze whether or not that relocation would be granted.
Practically, they do look at a lot of the same. They still have courts and judges are going to still have a lot of the same concerns at the initial judgment point as they do post-judgment, which is just that, is this child going to be able to continue having a meaningful relationship with both parents?
Right.
Which is typically, it's one of the presumptions that, where it's possible, shared physical custody is in the best interest of the child. Maintaining relationships with both parents is in the best interest of the child. So if one person is looking to relocate, and that would presumably take them far away, and it would make it impractical to have contact with the other parent weekly or every other week, the court's going to really take that into consideration and really carefully assess all the factors to determine whether that move is in the best interest. But so
Right.
you still are fighting a little bit of an uphill battle because, like we've said before, courts do like to maintain the status quo for children. They find that, for children, kind of keeping them in their current environment, if that environment again has proven beneficial for them, and that's allowed them to have contact and relationship with both parents, they're going to favor that, unless you can really show that a move would be an improvement upon that.
Yeah, you said a little bit of a uphill battle. I think it's always going to be a lot of bit of an uphill battle if you're trying to relocate far away with your children. I just heard this saying recently that it's the kind of the family relations office at the courthouse. They're saying is relo, hell no, where they're very reluctant to grant relocations because, again, it sort of makes sense if you think about it that a relocation generally will require that the children just sort of can't see one of their parents on a regular basis. And in the vast majority of situations where both parents are actively involved in a child's life, the court is just not willing to allow that to happen. They're not going to let somebody just move far away with the kids where they can't see the other parent on a regular basis.
Right. Like in the absence of evidence that shows that the child doesn't really have a meaningful relationship with that other parent, or there are other factors that really count against the child's well-being in the current environment, the judge is going to look and say, you chose to have children here with this other person. This other person wants to maintain their relationship with their child. We're not going to let you just move the child away from them. Where there are opportunities where you currently are. The child is living well here, and there's no real compelling reason to move. They're really not going to disrupt the relationship with the other parent.
All right. So what does this actually look like in practice if one parent is seeking to move somewhere far away? So oftentimes it's tough to negotiate an agreement. If somebody is really fixated on moving far away, it sort of, you can't make a lot of progress. It gets sort of deadlocked in the beginning. So in almost all of those situations, the court isn't just going to have a trial and make a decision. They have very limited information about your family. What they are going to want to do is either appoint a guardian ad litem, and that's a separate third-party individual who represents the best interest of the child, or they will have the family relations office do a comprehensive custody evaluation. So both of those scenarios would mean that a third party is going to do a deep dive into your family dynamics. They're going to talk to both parents. They're going to talk to your child or children if they're old enough to sort of have a meaningful conversation with them. They may talk to other third parties who know your family. They may pull DCF records or police records if there's been any history of police involvement or DCF involvement. They're really going to talk to all of the relevant people, including the parents. They'll look at communication between the two of you. They'll get an understanding of each parent's historical involvement with the kids. And they will ultimately, after doing that deep dive into your family, they will make a recommendation about what they think should happen. So should the relocation be granted or denied? And they will, after doing that deep dive, try to work with the parents to try to help them reach an agreement. They may say, listen, like, I just don't think a court is going to grant this relocation. Or, hey, like, I think it's very possible that a court is going to grant this relocation. I think it's in the best interest of the kids for this relocation to happen. So they will kind of come up with their conclusion about what they think should happen and try to help the parents reach an agreement based on that conclusion. And then if the parents can't reach an agreement, you have a trial where everybody puts on evidence, and the strongest piece of evidence in that trial is going to be the testimony of that guardian ad litem or family relations person, because that is the neutral third party who doesn't really have any skin in the game as far as favoring one parent or the other. They're just looking out for the best interest of the kid, and they are going to tell the judge whether or not the relocation is in the best interest of the child or children. And usually the judge is going to follow that recommendation because, they're going to listen to the person who's neutral and knows the most about the family, more than a judge can really know with their limited involvement in a trial. The judge does not have to follow the recommendation of the neutral party, but they oftentimes do. Again, they want to follow sort of that person's discretion.
And if the conclusion of the evaluation, the GAL or the family relations officer is leaning towards yes, like we would recommend the relocation in these circumstances. In that scenario, again, there's more likelihood, honestly, that maybe we will come to some kind of an agreement, because then we're really focusing on, or the GAL or family relations officer is focusing on, how do we carve up the summer or the holidays or the breaks to make sure that the parent who isn't relocating gets to see the child as much as possible on these other days in the year, where the child isn't in school and isn't bound by like a school calendar. So that, and then also the conversation surrounding child support and deviating downwards to account for extraordinary travel expenses, so that the parent, again, who's not relocating, in order for them to exercise their parenting time, if they are having to spend more to do that, or who's responsible for the cost of the child's transportation to allow the other parent to exercise their parenting time. All these become opportunities to try and negotiate some kind of agreement. And again, just keep it out of a trial. But I do find where the evaluation comes back with a recommendation against relocation, if that parent who really wants to relocate saying, I can't stay here, I have to relocate, and the recommendation is sort of against that, then, you're more likely than not at that point gearing up for a trial.
Right. Unless that parent decides like it's not worth, like, I don't want to spend the money on a trial if I know I'm going to lose. If family relations is recommending I not go, then I'm probably not going to be able to go. So I don't really want to spend the time and energy on a trial. I'd rather just try to reach some agreement on, maybe I still move and the kids live primarily with the person who's staying, and then I figure out what my expanding parenting time is going to be. So there's always, room for reaching an agreement, where the person who is not going to be geographically close to the child during the majority of the year, you can give them significant parenting time during breaks. So during summer break, or maybe they get every single spring break and Christmas break. So you can reach an agreement where you can avoid trial in a relocation case by reaching some sort of compromise to give the non-close parent as much time as possible. So those are the basics on relocation cases here in Connecticut. They can be very difficult cases, but it's always best to try to reach an agreement after, working with family relations or a guardian ad litem. Hopefully they can help your family reach some sort of compromise that will allow the relocation or not, depending on the circumstances and their recommendation. Nicole, do you have any wise words to add before we part ways here today?
Just that if you have a child with someone here in Connecticut, and you're now going through a divorce or you're in the middle of a custody case, just anticipate that if the other parent lives here too and they have a relationship with the child and they want to continue having a relationship with the child, you're likely stuck here. More often than not, you are stuck here. You made that decision to have a child with someone here, and now that you're no longer with that co-parent, at the end of the day, the child still gets to be with both parents. So you don't get to act like a single parent and move the child wherever you want. The other parent's relationship is as important, and unless there's really compelling circumstances to warrant a relocation, it's oftentimes not successful.
So that's going to do it for this week's episode of the Irretrievable Breakdown podcast. As usual, if you have any additional questions, you can contact our office, Dolan Divorce Lawyers. And if you are looking for representation in a divorce or family law case here in Connecticut, we would invite you to contact our office as well.